Hi, everybody. Welcome. Ray Dickey from Association Help Now, South Carolina CAI, Hudson Valley CAI. Thank you so much for being here. This topic came up kind of out of nowhere. Somebody sent it to me. Maybe it was Cory. I'm not sure who sent it to me. When an HOA files for bankruptcy, Cory is going to fill us in. This took place in Florida. And I have 1,000 questions in regard to it. I'm sure Dave does also. And I hope you do also in the audience. Everyone has a question feature. Please ask questions. I love it. Please. It makes it so much more interesting if I know everyone is out there and sending me comments. I'm going to do something a little bit different today with the CEUs because we're offering these courses online, some of them as pre-recorded that you can get CEUs. If you are here for CEUs, you need to use your question feature and you need to simply write need CEUs. And Cory and Dave, this should pop up 2 more times today, maybe around midway of the program and towards the end. This is what we need to give CAMICB to let them know that people are here for the CEU. So I'm going to give you plenty of warning. We're going to do this a couple more times, and that will tell me that you are here. So once again, if you need CEUs, just type in need CEUs. With that being said, I'm going to have our panel introduce themselves with who I see first, and that's Cory.
Good afternoon, everyone. Thank you, Ray, for having me again. My name is Cory Kravit. I am the managing principal of Kovich, Schifrin, Nesbitt's Florida office. We're based in Boca Raton, Florida, which is about 10 or 15 minutes from the condominium we're going to talk about today.
What's the weather? I'm in New Jersey, and it's like 1.5 feet, and it's still snowing. What do you have?
Cold. It's sunny, but it's about 50, 60 degrees here.
Okay, yeah, that sounds really cold. Dave.
Even when I'm only one of 2 on a panel, I'm still the last one to go. My name is Dave Byrne, and I am the chairperson of my law firm's community association practice, Ansel, Grimm and Aaron, and we represent HOAs, condos, and co-ops in New Jersey, New York, and Pennsylvania.
You know what, Dave? Since you're on so much, the next one I'm going to do a big announcement. Make everybody be quiet, and you're going to go first. How's that sound?
Wait, what if I just start reading like the Declaration of Independence or something?
Well, then we may have to cut you off then. So I'm not sure. All right, so Cory, kind of start us off here. Let's break it into pieces so our audience can follow along, and Dave and I can ask questions as we go along. What the heck is going on? I didn't even know associations could go bankrupt, but get us started.
Sure. This is a Chapter 11 bankruptcy of a condominium. It's a recreation condominium, so it's basically like the clubhouse and recreation facilities. And the condominium is the way it generates its money is from 2 other actual residential condominiums that pay assessments to the recreational condominium. This particular condominium. And I'm not involved in the litigation at all. The information I have is just public record from reading the pleadings. Essentially, one of the condominiums stopped paying the recreational condominium, so it's receiving about half the cash flow that's supposed to. And then there was a lot of litigation related to a development deal they did where they're converting the golf course. They basically took the golf course, gave development rights to a developer, and there's some disagreements there. So there's been a ton of litigation, and one of the condominiums stopped paying. That's the genesis of their cash flow issues.
The condominium that is claiming bankruptcy, what they did file bankruptcy, correct?
They filed Chapter 11 bankruptcy.
Their income was generated, you said, from 3 places, right? 2 other sub-associations?
2 other condominium associations pay directly.
Okay, so they're a master association, is that accurate? Or not?
Sort of. It's for a recreational tract.
Explain that to me. So they're getting, why are you bringing that up? What's the difference here? What's the difference if they were like a master association or something? Explain the difference.
I think there's also a master association for this community that manages, access points, roads, common areas. And this is the recreational facilities. If they have tennis courts, pickleball court, I don't know what this particular association has, but for instance, if they had a clubhouse, a pool, tennis courts, that tract is maintained just from, and only those two condos would be able to use that recreational facility. And then there may be other condos and other recreational facilities for, within the same master community.
Is that normal to, I mean, there's a lot of recreational facilities that are shared by different associations, correct? Is that a normal setup for that where it's actually its own? And what does that mean? The owners are part of two associations? How does that work?
Possibly three. It was more popular in the 70s and early 80s. Not so much now, but this is when, they would build these huge communities, come down from the Northeast and this is your retirement area. But I mean, these people, they would have their individual condo that they're members of, the recreation facility, and then the master association.
And this is like the golf courses that people get kind of thrown into, right? You're thrown in, when you buy into this community, you have to buy into this recreational community. You're on the hook for it.
In this particular, yes. Sometimes the country clubs are private, and sometimes it's optional, sometimes it's not.
Dave, any questions in regard to how, I mean, you would know anyway, but the audience may want to know exactly what the breakdown is and the relationship between the associations before Cory dives in a little bit further.
No, I'm good. Cory's probably read the pleadings and stuff. The intricacies probably requires like an in-depth look at the declaration and all the planning records as to how these things are supposed to get along.
All right, so I'm John Doe. I live in Association A. Association A is paying money towards the recreational association, which I'm almost also an owner in. So I'm John Doe. I'm an owner in both. And I'm like, something's wrong. Tell me, like, what was the stages? How did this recreational association ever get so far behind? I changed my mind. Why the heck wasn't the other association paying them? You said that was like a third of their money, right?
Yeah, based on the pleadings, it looks like there's about $500,000 that was missing out of their budget because only half of their budget's about $1 million paid by the two buildings. One building stopped paying, and so they lost half their budget right there.
Why? Why did the other association stop paying?
I didn't dig that deep into it. It wasn't disclosed in the pleadings, but perhaps they're not happy with the maintenance of facilities. Maybe the pool, the pool chairs are falling apart. The deck needs to be redone. A lot of these communities are older now, and then they're just simply not shiny and pretty like they used to be, and not being maintained to the levels of where maybe they should be.
And I know, like, you were nice enough to research this, so you didn't dive deep. You got your day job to do. Did the recreational association end up suing? Is there litigation against the other smaller association that owes them the $500,000?
I would hope so. I believe there was. I don't know what the outcome was. Again, I only looked. This particular case has many other lawsuits in state court. Bankruptcy is federal court. There's many other lawsuits in state court and also in the state appellate courts related to all the different players. So I believe there was at least 3 or 4 other lawsuits, and I candidly didn't have the time to read all of them.
And what were their assets and liabilities again? How much money are we talking here? I have it. You want
budget, me to?
It says 10 to 50 million assets estimated, and liabilities about the same. I mean, that's as good as whatever the internet told me.
That could be right. The unfortunate part in a bankruptcy like this, the assets are kind of irrelevant because it's not like they're going to be sold. Like if an airplane files Chapter 11 and it's got $50 million of assets, it's got $50 million worth of computer systems and airplanes, and then it can sell them and pay people 50 cents on the dollar. If the assets of a bankrupt debtor are a clubhouse and land, it's all deed restricted. They can't sell it to like a developer for, to satisfy creditors.
It says
So,
they have a debt of 43.7 million, and the largest creditor is this developer, Cory.
hmm And that's the developer who's supposed to be developing the golf course into new homes, and also building a new recreational tract to replace the current one.
Okay, so they're also like part of this in a way, but then they're also a creditor at the same time.
It's just a complete mess.
But this scenario isn't an uncommon scenario, meaning this arrangement, correct?
No, it's common.
Right, it's common. So this theoretically could happen, to just about any association if they let things get out of control.
I mean, that's the key, letting things get out of control. I think, other bankruptcies that I have been involved in, it's usually been the mismanagement of the board of directors, to the point where another member of the community will file for a receiver, or somehow it gets into bankruptcy court and the trustee acts as a receiver and takes the association over.
So Dave, the $1 million question here is, at least I think it is, and 3 people have asked me it already. Let's just jump ahead. What do you think the main question here is? You want to take a wild guess?
well, they're all unsecured creditors,
Well,
which means that their claims could be extinguished. I don't know.
here's the question, and is the question I had for Cory. I didn't want to even ask him when we were on here before we went live. How can an association, just a normal association, how can they go bankrupt? Like, I live in a high rise. Let's say my association goes bankrupt. What keeps the creditors for just coming after me as an owner, along with all my other fellow owners?
Well, that's what the bankruptcy kind of does. It creates an automatic stay, which means the creditors cannot go after the association. Um, any kind of state court proceeding would be stayed, essentially put on pause until the bankruptcy court has the time to reorganize. So some debts may be reduced, some put on payment plans. That's usually how that works.
Someone from the audience is asking, is this a self-managed property? Do you know?
I don't know. I do know I believe it's a 55 and up community, and most of the people there are elderly.
I still don't understand how, and Dave, I know this has come up on other live streams that we've been on. I don't know if you told me this or not, but I still don't understand how the association could go bankrupt. Why can't the association just levy an assessment on let's say the money is 500,000, right? And let's just say there's 1,000 owners. Why not just levy an assessment of $50,000 on every owner? Wouldn't the association have a liability, Dave, before I go back to Cory, to chase every owner then?
Yes. My experience with HOA bankruptcy or condo bankruptcy is that it's not a solution to anything, because people I think are under the misconception that when you file bankruptcy, you somehow don't have to pay anybody anymore, and it's not really the truth. There's 2 different types of bankruptcies. There's a Chapter 7 bankruptcy and a Chapter 11 for corporations. Chapter 13 is for regular people. But Chapter 7 I call like the give up bankruptcy. When you file a Chapter 7, you're basically saying, take all my stuff, pay whoever you want to pay, and never call me again. A Chapter 11 is like a timeout bankruptcy. All right, hold on a minute. Like Cory said, I want to pay everybody, but you got to stop levying on my bank account, because I can't freaking pay anybody if you keep taking money out of my account. Or if you seize my car, I can't get to work, and therefore I can't pay anybody with my wages. So that's what a Chapter 11 is. That if all the debts are unsecured, then theoretically they could be extinguished, but they can only be extinguished if the bankrupt debtor has no assets. So if the bankrupt debtor has assets, and to me, the assets would be the ability to get people to pay. That's the asset. The asset is I can force my members to pay, or I take their land. And so Lennar, let's say, who's got a large claim, $20-some million unsecured claim, is not going to voluntarily agree to take half the money. It's going to be an adverse party in the bankruptcy. It's going to hire lawyers, and in the bankruptcy in federal court, it's going to say my debt is protected. Yes, I'm unsecured, which means ordinarily I might be stuck. But here, this condo, all it has to do is just assess its members and pay me. And that's what will likely happen. So the people who own there are going to face stiff assessments. Many will not be able to pay. They'll get foreclosed on by the condo, and then the condo will own the unit after a sheriff sale maybe. And there's a lot of complicated things that can happen. But bankruptcy doesn't usually help a condominium because although most of the debts are unsecured, because a condo can't give out like a mortgage or anything usually, most debts are unsecured. The condo has the ability to raise the money. So it's not bankrupt. Like it actually, you know what I mean? Like you're not bankrupt if you can get the money.
But this is the second bankruptcy story I've heard like recently though. So, right, Cory, I meant obviously there is something going on here with this. And unless this is all just a technique just for a stay, but like, are we really sure what happens if an association really can't pay and the owners really can't pay and the assessments are going to absolutely ruin the association, right? Because if enough people don't pay, the money's not going to come in, right? Would that be a legitimate reason to go bankrupt?
Yeah, and sometimes the board refuses to pass the special assessment. And if the board refuses to pass the special assessment, then the bankruptcy court can appoint a trustee to essentially take over the board, and put in a new management company, put in new board members, or act as the board and pass the assessment itself and
collect the assessment. Yeah.
Mm-hmm.
But that really stinks if you're like the one rich dude in the association, right? Like everyone else doesn't have the money and you have the money. Like theoretically, as people drop off, if you don't do that, you're going to be left holding the bag. Let's say you have $1 billion, right? And everyone else doesn't pay. Can't they just, as the other owners drop off and take on their own bankruptcy, eventually somebody's going to be stuck with most of it, right? That's why I could see maybe why an association could go bankrupt.
If that would, I mean, you're only responsible for your proportionate share. So, you're not going to have to, if you're the only guy with money, you're still only paying your fair share. However, if you own multiple units, then there's been situations where developers have come in, they own half the apartments, and they could get stuck with a pretty large bill.
There's a lot of questions here, and I'm going to get to them, audience. Let me just ask Dave one quick question. Dave, based on what Cory said, I did not know that. So if you live in an association and there's 100 units and your fair share is $1,000, but over time, the association can't collect from 50 of those units. I always thought that your share would have to go up then to make up the difference.
Well, your share doesn't go up. It's like, I don't know. I'd have to ask my daughter because she's an economics expert now, but your share doesn't go up. You just have to pay more to cover what people aren't paying. So if everyone's paying the bills, and that means $1,000 per unit, but only 50 people are paying, that means you have let's say $50,000 deficit. That means that everybody who's paying has to pay $2,000, right? That's my math is correct, I think, right? So it doesn't mean you increase your share. It means you basically have to get your assessments go up to cover the people that don't pay, which is like any other situation. I guess if you live in a town and half your taxpayers don't pay their property, although taxes are a bad example because people buy tax liens. That's probably not a good analogy, but.
Okay, so Cory, that's what I was kind of, when you said that, like, let me just rephrase it. The percentage, okay, so I'm sorry, your share doesn't go up, Dave, but the percentage of the money that is owed certainly goes up.
Yeah.
Owners drop off. So Cory, that's kind of like the opposite of what I got confused about what you said. Can you re-explain it?
Well, the options are, foreclosure in Florida. So if you don't pay, it's similar to a tax deed sale. If you don't pay, the property will go to foreclosure and someone can buy it at auction, and that money comes back to the association when it's sold by the clerk of the court.
And you have non-judicial foreclosures, right?
No, they are judicial.
Oh, they are.
But they're, I mean, candidly, they're not that difficult because they're black or white cases. You either pay or you didn't pay. So they're pushed through the system generally fairly quickly. But in the meantime, if you have $1 million budget and you only have $500,000, the other people are going to have to cover that deficit through a special assessment, because you still need that $1 million to maintain the property.
Right. So as long as there's someone, I'm going to get to the questions, but as long as there's someone out there, theoretically a billionaire, at the end of the day, as all the dominoes fall, they're going to get stuck if they have the money.
If you're the, yeah, if
Yeah,
you're the
because I
last
guess
guy
what you're
and
saying
they
is
don't foreclose.
sorry, Cory. I guess what you're saying is you'll just keep raising assessments, and that the only person who can actually afford to pay them is the one last person. Then that theoretically, I guess, means he or she'd be funding the whole place.
Right.
The foreclosures foreclosure won't be very attractive at some point, meaning the foreclosure of a unit in this place, even if it has equity, if it's facing $100,000 assessments, nobody's going to buy it at a sheriff's sale. So it's going to be, it's not going to result in any money.
All right, let me get to some of these questions. I know we're jumping around today, which is fine. I think it's the only way I can keep up with the questions. If an association owns real property, how can that not be sold? I was thinking the same thing. So Cory, I'm envisioning, let's do the best case scenario, this beautiful rec center, right? And they owe the developer money. Well, why can't the developer take over the property and the rec center and use it in another manner? Maybe there's an association next door they can use it for. Why can't that happen? Why isn't that possible?
Because at least in this case, it's a condominium association and not an HOA. An HOA, the actual homeowners association, owns the real property. In a condominium association, each person has an ownership share in it. So technically, in order to do that condo association would need to be terminated, and then they could sell the property.
This is another thing I was wondering. Go ahead, Dave.
Let me jump in. I think I agree with Cory completely. The HOA thing is interesting because I think an HOA could be forced to sell the gym equipment, let's say, or the TV in the card room or something. But the real property itself, like the land, like the detention basin and the private road, these are all deed restricted. Like they're all, someone else can own them. I agree with Cory, their own, typically they're deeds in an HOA. They're actually a deed to a road lot or to a detention basin or to a pickleball court. That might be different if it's inside, I'm not really sure, but an outside tennis court or something. These are like real property, but they're deed restricted. So if you own them, you can't do anything with them other than offer them to the same people that had access to them originally. So that they don't have any value as a standalone piece of property.
Doesn't seem fair.
I think
it doesn't seem fair to the creditors that, like, no one else in the world can get away with this, but because
that's why I don't know what it's like in Florida, Cory, but that's like why in the Northeast it's been a relatively new development that banks have gotten comfortable loaning money to associations, because if you own a home, a regular American owns a home, he or she goes to a bank, you want to get a mortgage, the bank sends a guy out to do an appraisal. They say your house is worth 600 grand, we'll loan you 300 grand, and if you don't pay, we'll take your house. And at that point, the house is worth 600. We'll sell it. We'll get our money back, the 300 we loaned you, and then everybody will be happy. But in Cory said, in the condo context, a bank loans money to a condo. The bank doesn't get any secured debt. It doesn't get any mortgage on individual units. It has nothing. It has no paper. It has no security interest. Which is why in this bankruptcy that we're talking about, all the creditors are quote unquote unsecured. It's basically like a credit card debt, just a really big Visa card that didn't get paid. It's not like an unpaid mortgage. Unpaid mortgages have a lot of rights in bankruptcy. Visa and MasterCard, they're screwed in bankruptcy usually.
Well, in Florida, the banks take the lien rights of the association, so the banks could lien and foreclose. Just like the association, stand in the shoes of the association.
Yeah, if they borrow money through the bank, right? If they borrow the money through the bank. Yeah, I agree with that. Yeah. That's what happens
Right.
here too.
I love the questions. Thank you. Let me get to some of them. I'll start. Corey, what happens at the what happens to the condo association monies that paid their dollars? Well, maybe I don't understand the question 100%, but like, what happens to the money that's already, maybe the association already has some money, right? That could easily be.
Yeah. They're
Okay.
still maintaining, they still have an obligation to cut the grass and do whatever they do. Pay their employees, pay their maintenance guys. So I'm assuming that's where that money is, they're paying the people who are, number one, you have to have insurance. So they should be paying their insurance. They should be paying the people who are showing up to work, because I doubt anybody's, working for free. And then, they're picking and choosing who they're paying based on, their priorities.
All right. So this is a great question. What would be the best option? Legal dissolution? Did I say that right? Or bankruptcy, or do you have to do both? Let me just mention one thing before you answer that. I'll go to Cory and then Dave. I know in South Carolina, I may be remembering this wrong, everybody. There's legislation that's probably never going to pass where only like if you get 65% of the owners, they can dissolve the association, which sounds crazy, but I'm pretty sure I have that right. And I was shocked to hear this is somewhat of a common theme that's taking place in other parts of the country. Now, doesn't mean these things are going to actually become law, but they're actually being thrown out there where they want to legislate like, hey, if owners get together as low as 65%, they can dissolve the HOA. So back to this question, which I think kind of means that it's a really great question. What would be the best option? Legal dissolution, you can re-say it for me, or bankruptcy, or do you have to do both, Cory?
Well, in Florida, it's called a termination. Other states call it deconversion, where you're basically terminating the condo and turning them into apartments where there's, a single owner that owns them all. There is a termination statute in Florida. Our firm does do terminations. We've actually done about 100 of them in Chicago. So, and terminations are a good idea when it's no longer financially viable to maintain. It costs more to fix than it's worth. It's better to start, knock the building down, redevelop it, sell it to a developer, and that to prevent economic waste. So, but when you do terminate, that doesn't mean your debts get wiped out. Those debts still need to be satisfied. So the bankruptcy, I don't know what's going to happen in this case. It was filed this year. It was filed in January, so it's still very early. But I would, and this is not the residential buildings either. It's just the recreational tracks. So, my guess is that, the various lawsuits will be settled. And a trustee will either direct the board, either the bankruptcy judge will either direct the board to special assess, make the other condo start paying, or a trustee will be put in place to force it.
Yeah, see, in bankruptcy, the value, Cory's made an interesting comment there. The value of the bankruptcy could be that it might be better for the owners to get rid of amenities, or to sell them off to an outside company. Let's say you have a golf course, no one uses it anymore, but you're stuck with it. You know what I mean? So, but you can't sell it because you have a declaration or master deed or something that controls how you use the golf course. Like the board can't sell it, right? It's like deed restricted. But in bankruptcy, all bets are off. I mean, a bankruptcy judge can just he or she would have to have some basis to do it in law, but they have the jurisdiction as a federal judge and a bankruptcy court to basically void the whole thing. So like a judge could void a declaration and say, from now on, all this recreational crap, I'm cutting it out of your community. So, and then my trustee is going to sell it. And from the amount of money I get, my trustee is going to pay off all the people. But you people are no longer going to be able to have this stuff. I'm going to take your community. I'm going to slice out this part. I'm going to slice out that
Right.
part. That's doable in bankruptcy court, and it's not doable necessarily in state court unless all the owners vote for it.
So many questions, but then why don't I just do a live stream on, hey, if you're a board and you don't want to be responsible for your pool anymore and you want to get rid of it and unload it, why don't you just get your association to go into bankruptcy? Because then basically you can go ahead and make those changes and it'll be up to the judge. But at the end of the day, you could get away with it.
Well, someone would have to, in order to file bankruptcy, you'd have to have some basis.
Right.
Well,
right. Well, that's the next question.
You mean like you don't pay the pool company, and then instead of paying them, you file?
Well, I'm just saying theoretically, if an association, there's an advantage to this bankruptcy. That's not just the fact that it's going to have a stay on their finances. What I'm hearing is there's an advantage for the association maybe to unload some aspects of the association with the judge's approval that they could have never unloaded if they never claimed bankruptcy.
There might be, because of what, like the comment Cory made, which was, the condominium involved is recreational assets. It's like a recreational association. The bankruptcies that I'm familiar with, where I practice, the two of them that have been done, I've never done one. They were done by other people, but in those situations that wasn't available. It was a straight out condominium, and they did nothing other than just force the owners to pay massive assessments to satisfy all the creditors. Like in those bankruptcies, they file them simply to avoid their account being levied. Like, they knew they had to pay everybody, but they couldn't pay everybody at once. They needed a federal judge to say, okay, you landscaper, you're getting paid over 30 years. You pool guy, you're getting paid over 20 years. It wasn't like they got freed of their debts. They only got a court imposed payment plan. But if you're dealing with a recreational association where your assets might actually just be, like open space, not detention bases, not useful property like that, but a soccer field, stuff like that. Maybe they could, maybe the bankruptcy could carve it out.
All right. Let me get to some of these questions. I have to do this too. You don't have to do this if you're in the audience right now, because I know exactly how long you're here for. If you're watching this in the video portion, I'm going to put this up. You have to type in right now, I need CEUs now. You don't have to do it right now, audience. This is for these pre-recorded CEUs that we're going to be doing. This allows us to tell CMICB who was there. Our system's a little bit different for the pre-recorded. So if you're watching the pre-recorded session right now and you want CEUs, you need to do this. If you don't do it, you're not going to get CEUs because you're not here. So you, audience, don't have to do it right now. You can if you want, but if it's the pre-recorded session and you're here right now, maybe I should have never said that, Cory, because people are easily confused. Not our audience, but the audience watching this later. You need to do it if you want your CEUs. With that being said, let me hit some more of the questions here. With these older units that are kept up, do you see this happening more and more in Florida? Cory, do you see this happening more and more?
No, not necessarily bankruptcy. I think that this was a perfect storm. This particular case was a perfect storm of, one condo not paying and a ton of litigation. And most of their debt is to lawyers. I see more commonly older buildings where it's not worth, they might need a few $1 million of work, and the people living there can't afford that special assessment, because they're on fixed incomes and they bought it 30 years ago. In that situation, terminating the condo is actually a really good idea, because in most scenarios, you're going to get paid above market value for your unit. You may have the option to rent it at below market value for a year or so. And it's often hard to sell those units because people know the amount of work that needs to be done and the special assessment that would be coming for it. So I think terminations are probably more likely, especially in South Florida, where the condos, the condos are approaching, 30, 40 years of age.
Why not just go bankrupt first and try to get rid of as much of that debt as you can? If you're going to terminate it anyway, it'll be more money in your pocket. That's what people do in bankruptcy.
But you can't discharge your debts if you have money. It's not like bankruptcy is not like a legalized way to commit fraud. I mean, if you can pay a bill, you're supposed to pay it.
But people do it though, Dave. They do come up with ways to, skirt the morality of it, right? And without. Go ahead,
Cory. I agree. Cory,
at the end of the day, it costs more because the money has to come from somewhere, and it's going to come from the unit owners.
Well, here's the other question. Like, our board can't pass, so many questions. Thanks, audience. A board can't pass a special assessment without the majority vote of the owners. We have a recreational HOA that everyone must pay a yearly fee. If they don't foreclose on their, if they don't pay, we foreclose on their unit. Yeah, then it makes perfect sense. I don't know how this got so out of control and why this would impact the bankruptcy at the end of the day, Cory. It almost seems
and
like
I think the bankruptcy is going to force them to foreclose.
also,
Yeah, I would think this bankruptcy is 6 months from now it won't exist anymore. It probably was just a way to slow something down. Maybe their litigation was going to trial in a month and they weren't ready, so they filed bankruptcy. I mean, it's not it's possible this is just a ploy, not necessarily a ploy like in a fraud kind of way, but like a strategy, I say is a better word, a strategy to reset the table, maybe get some negotiating leverage, different types of things.
that's what I kind of just was saying before, though, in a way, using bankruptcy as a tool. If you have a legitimate reason to do so, why fight it through termination if you have close of a reason to go into bankruptcy?
But in your example, in the end, it's a ploy only, it's going to get dismissed.
Yeah.
Eventually. So
well,
nothing's going to change. Nothing's going to change.
Right.
You know what I mean? Like, it's not like it's a ploy to get what you want substantively. It's a ploy to delay people from chasing you. You get to hide out a little longer.
I feel like people always get stuck in these bankruptcies that shouldn't get stuck in, and it seems like the people always get away with not paying something, but that's whatever. I'm used to the private world, not associations. Also, how can a board, the same question, how can a board need owner permission for a special assessment, but they can put an association in a bankruptcy? Yeah, Cory, I've been thinking this all along. Like, can a board just let an association go into bankruptcy? Can they have a vote that says, hey, everybody, we decided at the last meeting to go bankrupt? Like, how did this even come about?
I mean, in this particular, yeah, the board has the ability to file bankruptcy, certainly. It's a corporation at the end of the day, and corporations have the ability to file Chapter 13 when they have a bunch of bills to pay and they can't pay it.
Okay, but there's all these laws to protect owners in other matters, but there's not one to protect them from the board just deciding to do bankruptcy.
Well, because you're assuming that if I file bankruptcy, that somehow then it's over and we go watch TV. No, I know you. I'm saying bankruptcy is just the word. When you file bankruptcy, you're simply opening up a legal process, which most of the time results in a dismissal because you've not satisfied the elements of getting bankruptcy protection. You know, there's like a bunch of things you have to, and people file opposition. Like, it's not a free ride. The people that you owe money to, they hire lawyers and they go to bankruptcy and they say, this is outrageous. I want this, I want that. And it doesn't, oftentimes it's really just a way to slow things down. If the company that's filing bankruptcy actually has assets or the ability to raise money, it's not and that's not an airline that no longer has customers and has no money. If it's a corporation that has money or has the ability to get money, then the federal judge bankruptcy will make you pay it
eventually. But eventually, I'm going to not stick with this, but I'll give you an example here. Man, I would not want the board to have the ability to declare bankruptcy on their own. There's a stigma involved with that I'd be uncomfortable with. There's the value of the sales of the, there's long-term effects. I don't know if I would feel comfortable with a board having the ability to declare bankruptcy on their own without input from the owners.
Let me respond. I know I'm jumping in often, but in response to that question, and I want to hear what Cory has to say too, but frankly, if a board is faced with a perilous infrastructure problem that sometimes leads to buildings falling down, and the owners refuse to fund the expenses, the board is in a very precarious fiduciary duty problem. Filing a bankruptcy may be the only way to protect itself. Whereas a federal judge may then force the owners to pay the assessment that they refuse to vote for. It may be like a legal strategy to get the owners to pay an assessment that the owners wouldn't voluntarily pay, but now they have no choice because a federal judge says you're going to pay it, and that's the way it's going to be.
Well, now I agree with it, Dave. You just convinced me. Cory.
And I think it's also important to reiterate that bankruptcy is under federal law, and most of your condo and HOA laws are state law. So, federal law will supersede in these situations, to force the actions that Dave mentioned.
Other commentary about units being older and not being kept up. They're different viewers, and they're asking about people not wanting tax liened properties. I'll start with you on this, Cory. Once again, we're back to this theme where people commenting, well, if the building's older and it's not kept up, don't you see people not wanting the tax lien properties? Commentary on that?
Tax liens are when you don't. Yeah, tax liens are when you don't pay your taxes.
Yeah.
So and they're superior to association liens or mortgages. So if somebody buys, the tax, pays the taxes and it goes to a tax deed sale, then it's a super foreclosure. Everything beneath it, you get title to the property. You don't have to pay the mortgage. The mortgage gets wiped out. The association fees gets wiped out. And it's rare if there are, if there is money owed on the property, usually it's cheaper for the bank. Let's say if the bank has a mortgage to pay those taxes to prevent the tax deed sale, because the bank risks whatever they loan, let's say $400,000 or $500,000 over a $10,000 tax bill. So that's usually not going to happen, especially if there's a lender involved.
So Dave, I think I know the answer to this. I think it's a great question, but I know what you're going to say. But let's see. Couldn't the board be found negligent of their fiduciary responsibilities towards the association? So therefore, couldn't the homeowner sue them for their negligence if they are special assessed for such a shortfall?
I mean, maybe, but it's not like the board members are going to have to go to their local ATM machine and take money out of their account to pay the people off. Suing board members is like suing yourself. It doesn't get you anywhere.
Right. That's what I was thinking. What's the point of suing the board if they're indemnified anyway, and you're just basically suing yourself for the money anyway?
Right. Unless you got somebody like, you caught stealing or something, then otherwise, if you're just suing a guy because he wasn't smart in how he handled the corporation's affairs, any judgment against him is going to be paid by the condominium anyway, which is you.
Plus, Cory, Dave just outlined a business judgment aspect to a board declaring bankruptcy, right? So you couldn't even get away with claiming that. Can you run with that, with what I'm trying to say?
Yeah, I mean, so you're protected from individual liability as long as you follow the advice of your experts. Your lawyers said, here's your option, file bankruptcy. So, you're completely indemnified at that point. The time to sue your individual board members if they breach fiduciary duty not protected by the business judgment rule, they're wealthy, and their assets and individual assets aren't protected, and the association's insurance won't cover the act because it was an intentional act or grossly negligent acts. So again, you might be able to win the case, but if the individual board member doesn't have any money, you just get a piece of paper.
So I'll start with Dave. This is interesting. So you said, and we're putting it in a spot. We put Cory in a spot, but you have an association. You own the association that owes the other association money. The recreational association is going to sue the association that you're already part of. So you're like suing yourself in a way, Dave, because these owners are part of both associations. How does that work? Or am I wrong?
No, I mean, it seems kind of illogical, but I guess if there's a association that has members from outside of your own community, then I guess you're really in a lot of ways pursuing the other community, I guess, for the money that's owed. But it's very, yeah, it's potentially confused.
Cory, it's confusing, right? I mean, am I off? The question the viewer asked and I added to it, it's a legit question, right?
Well, the hard part about, doing hypotheticals is that you don't really always, it's nothing set in, there's so many variables that are in place that until you get the actual facts, it can be confusing. And when you get the actual facts, then you can point in the proper direction.
Does every owner have to participate in the bankruptcy? How about if one owner has the resources to pay their percentage of what is owed? Cory.
There's no participation in the bankruptcy. The bankruptcy is between the association and its creditors and the court. If the bankruptcy judge has a trustee or receiver put in place, they're acting as the board of directors. And so the board of directors would issue a special assessment, and then yes, you would pay your part of that special assessment.
So theoretically, Dave, if you're an owner and your association goes bankrupt, stops paying all their bills, and no one ever goes after you personally, it's not going to impact your credit, your history, or anything, correct? Because they're two separate.
Right, correct. It won't impact your credit. No, not at all. It may impact the value of your home, but it wouldn't affect your actual like credit report. You're not on the hook for any of these debts personally.
Okay. A couple questions I just want to get through. They're not totally related, but I think they're just kind of important. I just want to touch base on. I have a friend who's on the board of a 55 and older community, and he overheard they do not have a reserve study and they were self-managed. This gave me some concern since it was an older community. Could I say something before you guys do? Yeah, I'd be concerned as hell. Cory, your legal opinion?
Yeah, there's certainly some potential issues. Perhaps, obviously, number one, raise it at a board meeting. Two, do a recall and take care of it yourself. Get on the board, or three, you have the ability. Individual board members have the ability to enforce the governing documents, just like the association does, and they can go that route. And potentially, I've been in litigation where individual members were, stuff wasn't being done properly, and they petitioned the court for a receiver to come in. The receiver wipes out the board and runs the association at a nice premium.
I don't know, Dave. Maybe if you can get out of there, go live somewhere else. Seems like
the reserve thing's always been interesting. When I first started doing this, representing associations in the mid '90s, and in New Jersey exclusively. At that point, it was just New Jersey. There were many associations that didn't have reserves at all, and it was natural. It was not a worry. Associations that did not have reserves tended to be associations down the shore, on the water, second home type places, where the owners made the probably reasonable calculation that we don't need to put money aside for a rainy day. If you need 20 grand from us to fix a roof, just gas us for 20 grand. Why am I giving you money to put in an account at 3% when I can hold my own money for myself, and then just call me when you need me? The reserves are important for associations now so much because people aren't thinking much about the future. So like if you're going to live in that condominium for the next 25, 30 years, you don't really care whether the roof falls off in 40 years. You know, like you lack the economic incentive to keep raising your personal taxes basically to fund the quality of your infrastructure 30 years later when you're not going to be there anymore.
I don't want to get sidetracked with reserve studies. Really quick though, Cory, I'll tell you, Dave and I used to do stuff in Manhattan, and we go to these billionaire buildings. They don't have reserves. They don't need them. They're billionaires. The guy sends out, says, hey, everybody has to chip in 300 grand. The owners don't even know it. The business manager writes a check for 300 grand and they put a new elevator in. So if everybody's got a lot of money, you don't need the reserves if you know people are going to pony up. Could a creditor ever go after a homeowner's? Well, I'm going to change this question. I'm a creditor and I go to the judge and I want to take over the association. I don't, I basically want to take it over. I want to become
In
the board.
bankruptcy or in state court?
And bankruptcy, or you guys could tell me how it would work.
Oh, okay.
Somebody asked this question and it was also emailed to me. It was two separate people, but I'm changing a little bit. Sometimes you can come over and you hear these stories, you could take over a company. There's all these things you could do. Couldn't a creditor come in and theoretically take over the association if they're owed that money, if they're the biggest creditor, and that could be a workaround to some kind of financial arrangement, or no, Cory?
I think that's pretty unlikely. I don't see a bankruptcy court doing that, but I think, like I said before, the more likely scenario would be, restructuring the debt, doing a payment plan, and enforcing special assessments to pay for it.
You can force if you're a creditor, you can force the debtor into bankruptcy involuntarily. If there is a mechanism for that, and then you could then try to use the bankruptcy process to force payments to you. That's how you would do it. But I've never seen it be used in this context. I've seen it used in association contexts, but not with the association as the one that is the one that's forced into bankruptcy. But it's doable. I mean, in state court, I don't know that if a landscaper is owed 150 grand, I can't imagine any judge would give the guy the ability to run the condo until he's paid. I don't even know if there's really no legal mechanism for that. His rights would be to get a judgment against the condominium or the HOA and then try to execute on it.
But what a powerful tool. I mean, I would love to do a session on that. I don't like to do clickbait, but like someone could force your association into bankruptcy to play dead. I mean, talking about if you're a creditor of an association, talking about like a powerful tool that is going to scare the heck out of the owners and get the board to pay you. And what you
might have to do that. Like if there's I don't know, it's kind of like what Cory was talking about before, I guess, but like, let's say you have a bunch of different associations, and there's an association in the front of a community that has to be maintained in order for you to have access to the road, and they don't pay to maintain the area. You may be able to get a judgment against them, but so what? Like, you don't have the right to actually do the work. Like, you don't need money. It's not like a landscaper is owed money who just wants the money. In this hypothetical, you don't want money. You want someone to do something. So maybe once you got a judgment against the HOA who refused to do the work that you needed done, you could force that entity into bankruptcy, and a federal judge would make them do the work.
Cory, that would be a really powerful tool.
I'd have to think about it more.
Right? I mean, it's going to scare the heck out of everybody, make the board look awful.
I was thinking about a situation where a brand new community where the developer turns over to the board completely runs it into the ground, where the developer is still selling a handful of homes. Could the developer recapture? I don't know if it would necessarily be through bankruptcy or through.
State court would give you a right to do that, at least in my states, because you could. We have all kinds of prohibitions against. Well, we have mandates statutorily that require a condo or HOA in development mandatorily have to keep up the same level of service and expense. But there, a developer would go to court, get a court order. If the association still refused to do it, maybe a judge would let them take back over. That's possible.
I love this comment, and it came in, Dave, when you were talking about the roads, and I appreciate the person that sent it in so much. Why couldn't the creditor put a toll up? I meant, like, maybe you go to the judge and you're like, hey, these people owe me money. I want to put a toll up to the entrance. Cory, while maybe unlikely, theoretically, is it even legally possible? Somebody puts a toll up to get in and out of your association. They collect their money $5 at a time for forever.
Never seen it done before, but it's a creative idea. I don't think it could be done. But it's interesting because then you're having your visitors kind of, shoulder a lot of the burden. But the maintenance responsibility is supposed to be done through assessments. The government documents are pretty clear by that. So that's why it's never been done. but I think it's certainly very creative.
We have a mechanism in New Jersey, and I gather it's similar in other states, but where the this is a perfect example because it's accurate. It's true. An HOA was built, and it had to, in order to get to it, you have to cross a river. So the developer built a bridge, built it correctly. There was never anything wrong with it, but 25 years later, it has to be replaced. And it's now 2024, let's say. The bridge was built in 1994. So now it costs $20 trillion to build it, as opposed to what it cost 30 years earlier. And the HOA just literally, I mean, even if they voted to fund it, it would be, like $100,000 a person or something. So the municipality can create a special private taxing district where the municipality they don't take ownership of the area, they don't take ownership of the real property, but they fund the work through property taxes. So the government is doing the work and then getting the money through property taxes, which is a lot, and the owners don't get to vote on that. So it makes no difference.
Dave, we don't want to make it that complicated. We just want to know if boards could put a toll up. Like they're like this board, right? They're on the hook. They got a bankruptcy. They got nothing else to lose. Hey, maybe they could put a toll up. And Cory brought up something. It's pretty scary, his thought process. Now you're like even getting visitors to pay. I mean, it's kind of funny, but man, if they could put a toll up legally, I don't know. Maybe it's I don't know. It's interesting.
Well, I think it is. I mean, look, the government could, in my example, the government could assume ownership of the area in question and then fund and then repay itself through tolls.
Yeah, but the boards want to have their own toll. It'd be more fun. Okay, so let's do this. While we're doing closing thoughts, you can do it if you want now, audience. If you're here for the pre-recorded session, you need to do your CEU. You need to send me something that says, hey, I need my CEUs now. I need that for CMICB to show that you were here for the allotted time. So just send me something that says, I need my CEUs now. For you, audience, right now, you don't need to because it's a different system. But you can. It won't hurt anything. With that being said, while they're doing that, Cory, and I'm going to take this off in about 20 seconds, 25 seconds. Once again, audience, for them watching this recorded session, make sure you put in CEUs now, the non-live version. That being said, Cory, why don't you give me closing thoughts here in the last couple of minutes? Or let's let you go last because you brought the story. Do you mind going last? Because it's kind of your turf and you researched it. Is that okay? Or do you want to go first?
I don't.
Well, you know what? Let's ask Dave because we know his feelings were hurt since he doesn't. Dave, what would you prefer? We want to make sure you're happy and make sure you come back. Do you want to go last or do you want to go now?
I'll go first, but I'll go fast so Cory gets the closing thought and he gets to speak longer. My closing thought is that bankruptcy is a really interesting topic for like live streams. It's interesting when you see it in a periodical or on the internet. You stop and read it. At least for guys like Cory and myself who do this work, we're like, "Oh, HOA condo files bankruptcy. What's this about?" But in reality, it doesn't happen. I've seen it twice in 3 states in 30 years. It was a disaster both times. Thank God I wasn't involved. But it's something that really doesn't happen. There's probably something more to this story. This bankruptcy is probably part of some overall strategy. So I don't see it as usually a big thing or an important thing to really learn much about.
Okay. Cory, take us out of here.
And the newspaper articles never really summarize what's actually going on. You really got to do a deep dive and read the pleadings, and and you got to read both sides. Sometimes the news articles will be, only get from one side and the other side doesn't have a comment. So you really have no idea, and I think that was true in this case to some extent. But the moral of the story is don't sit on your hands with collections. That was one of the big aspects that pushed this condo into bankruptcy. It's a hell of a lot easier for us to collect a little bit of money than it is a big amount of money. So don't sit on your hands. If you have delinquencies, go after them as quickly as your documents allow you to, and also don't get stuck in a ton of litigation that's going to drain your treasury.
Coming up next week, join us for our special session with Cory and Dave. You could put a toll up on your road to gain money. No more needing to raise assessments. put up a toll and a gate. That's going to be my next live stream.
The Cory
So,
Kravit
I'll be your-
Memorial Toll Bridge.
I'll be
I
your
love
toll
it.
booth operator.
Yeah, people are going to
Hey.
tune in. They want to do it. I want to thank you guys for being here. And audience, I love the questions. I know it was a deep dive, audience. Thank you so much. I like these kind of deep dive questions. And terminations. Yeah, we'll do it. People want more terminations. Cory, they're interested in that. So we want to hear more about that. Thanks, everybody. Thanks for being here. Bye. See you guys.
Bye-bye.
Thank you.